Hey friend, welcome back to my channel, True Crime Matters. I'm Tara Marie, and today I just wanted to take a few minutes to do a brief overview of the Scott Peterson 30-minute status hearing that was last week. Basically, the hearing centered around trying to set briefing schedules for 3 motions. 1, a motion for DNA testing, 2, a motion for post-conviction discovery, and 3, a motion to seal selected last names of individuals named in a 54-page letter that the Los Angeles Innocence Project sent to the district attorney of Stanislaus County on November 14th of 2023. Now, if you haven't watched my previous deep dives into what's in those motions, I will link those down below. But if you did watch them, you know that there is significant new evidence that has come to light in this case that the LA Innocence Project is asking for as soon as possible so that they can begin the lengthy process of testing it with their very sophisticated lab equipment. Now, one thing I wanted to note is that timing is of the essence for Scott Peterson's team. Now, he first filed a writ of habeas corpus on his own back of April last year when allegedly several witnesses came forward who provided specific details that they had heard a man apparently admit to participating in the burglary that happened across the street from the Petersons the day that Laci went missing. And the statement was that while they were burglarizing the neighbors, they were in the middle of removing a large safe from the home when Laci came out and threatened to call the police. These witnesses claim they heard this same man say this group of men that he was with took Laci and that the men that he was with killed her. And the thing is, those witnesses provided details that have never been made public about the case, which is pretty much why the LA Innocence Project is taking them seriously. And in the appeals system, once you file those documents, you're on the clock of the court. Now, everything is timed. Now, the DA replied pretty quickly, and while I don't know what they said, I'm pretty sure the DA's office did nothing. Now, a few months went by, and it looks like even more documents were filed with the court under seal around July. And then it looks like Scott retained a lawyer named Corinne Ferrantino. However, we have found out more recently that right around this time last summer, I believe I heard Scott and one of his original lawyers, who he worked with in 2003, wrote to the Innocence Project sometime last summer. And they wrote about this case asking for help regarding this new bombshell evidence. And it was after that, on the docket, we see Paula Mitchell's name kind of appearing here from the LA Innocence Project. So they agreed to take on this case because they truly believed that they have multiple pieces of evidence here that potentially point to other individuals committing this crime. Now, back in November of 2023, right after Paula Mitchell and the LA Innocence Project took on the case, they filed a motion to suspend the informal briefing because they knew this investigation was going to take time. So on December 1st, the court granted the suspension of 6 months. That means they're on a strict time budget here. Now, the funny, or I guess I should say not so funny thing is, the prosecution has known for a long time now that pieces of evidence have been requested, but yet nothing has been made available. So that's kind of the first part of the problem here. Where is that evidence, and why is it taking so long for them to hand over? In Superior Judge Elizabeth Hill's courtroom was Stanislaus County prosecutors David Harris and Birgit Fladiger, Scott's new team of lawyers who are with the LA Innocence Project, and Scott Peterson himself, who appeared via Zoom from Mule Creek State Prison. Now, Harris and Fladiger were a part of the original prosecution team from this case 20 years ago. And side note, it has also come out recently within the motions filed by the LA Innocence Project that there are multiple witnesses from both the DA's office and the Modesto Police Department who allege that Fladiger had an extramarital affair with one of the lead investigators in the Peterson case back at the time of trial. So There was some correspondence a few months ago with the LA Innocence Project and the prosecutor's office that this was a huge conflict of interest in the first place for them to be working on the same case if they were having an affair back then. And it's even more ridiculous if they remain on the case in present day. But so far, even though this was stated by the LA Innocence Project, and even though they are now both retired, both Harris and Fladiger are remaining on this case. Now, when I actually did get a chance to see the hearing, it began with Paula Mitchell, attorney for Scott, stating that her and her team went to the DA's office back in late February to try and resolve the issues then, but nothing was resolved.
We did go to the district attorney's office in Stanislaus County on February 13th to have a meet and confer. Unfortunately, we were unable to resolve any issues. I do have a letter memorializing the discussions that were had. If the court would like a copy, I'd be happy to provide that. I sent it to the district attorney's office on February 24th, just setting forth the issues we discussed and the impasses that we had.
Okay, thank you. Counsel for the people.
So we received the motion with all the attachments on January 9th. The AG's office, which also needed to be served, received the motion with the attachments, exhibits on January 23rd. So we will be ready to file our response by 90 days from either of those dates. We're looking at either April 22nd from when the AG was served or April 18th from when we were served.
The DA keeps pushing back on handing over any of the evidence requested.
Can I just inquire, we were given somewhat mixed signals at the meet and confer concerning whether the district attorney's office intends to file a blanket opposition to both motions or whether there are some specific items that they will be objecting to and others that they will not with respect to the discovery motion. So if the court could inquire whether they intend to file a blanket motion opposing all requests, or if it's with respect to certain items, perhaps we could begin receiving the items that they are not objecting to.
I mean, I would expect that counsel could handle that in the meet and confer process. So the people are entitled to an opportunity to respond. They can decide what the scope of their response is going to be. If you're going to need 2 weeks to respond to that, then I will set a hearing that contemplates that you will have time to file a reply and I will have time to read all of the pleadings before we have the hearing. So
during the hearing, it almost seemed like they were trying to milk the court clock or something by saying that they needed 90 days to review each piece.
Your Honor, if I might,
yes.
In terms of the timing of our response, I was speaking specifically about the DNA motion.
Mm-hmm.
That we'll be ready to respond to that on that date.
Okay.
And then we would ask for an opportunity to file a response to the discovery motion as well, and we would ask 90 days from the date we file the DNA motion to respond to the discovery motion.
Is there a reason that you need an additional 90 days beyond for the discovery motion, or why they can't go in parallel, Ms. Fladiger?
Yes.
Or Mr. Harris?
Yes. As the court may have already seen in the pleadings, the defense pleadings in this particular case, specifically for the DNA motion, is 142 pages of pleadings, plus over 880 pages of exhibits that are attached. The exhibits came to us later than the initial pleadings, and so that's been one of the delays for us, having to go through each of those particular exhibits. The statute for the DNA motion does have a 90-day deadline. The statute for the discovery does not have a deadline. It's been interpreted by the court to be a reasonable time frame.
Okay.
We think that the DNA motion would also assist, having that resolved would also assist in some aspects as to the discovery motion, because specifically in the statute it says that the two do not work necessarily in conjunction.
Right.
Also, the discovery motion itself is another 62 pages with a large volume of exhibits for that as well. So we've been concentrating on trying to get the DNA motion, which does have the deadline done. A lot of the materials that we will have in the DNA response will be applicable to the discovery, but we just think a reasonable time period based on the size of these motions. It's not unreasonable to ask for another period of time.
And even then, the judge kind of shut that down, basically saying, look, I don't think the Court of Appeals is going to think it's reasonable if you're taking up the entire span of the 6 months just to read and reply.
Well, I guess the concern that I have about 90 plus 90 in terms of your responsive pleadings is that the Court of Appeal has issued a stay for a relatively limited period of time. We're working on a 6-month deadline before, and I understand that there is the potential for an extension of that deadline if there's additional good cause, and not being done with the pleadings here and with the hearings here, determining the scope of the discovery would potentially be good cause. But given that they have sort of given us a 6-month time window to work with for what they think would be an initial opening, I'm concerned that setting a briefing schedule for that exhausts the entirety of that time period is not going to be viewed as potentially reasonable by them. So,
now here's just a few of the items they are asking for. A hammer left at the scene of the burglary at the Petersons' neighbor's home. I guess the idea might be that fingerprints might be on this item. Obviously, on a hammer, they would be holding it, and that could maybe potentially point to maybe other individuals who may have been present at the time of the burglary. Another item is a Target bag found near Laci's body, which had duct tape wrapped around it, possibly the same duct tape that was on Laci's pant leg. And the bag was also found to be the same type of bags that were used in a construction project on the Richmond Bridge, which is right where the bodies were discovered. So they're wanting to test that since it was never tested at the time of trial, believe it or not. But the biggest and most alarming piece of evidence they want tested is from a bloody mattress that was found in a van found abandoned and burned about 12 hours after Laci went missing, just about a mile from her home. It was found in a very bad area known for crime called the Airport District. Now, retired fire investigator Brian Spitulski was the original investigator of the van fire, and he has actually come forward recently saying he's been waiting for 20 years for this to be looked at further because he found it very unsettling that he had tested that mattress for blood and he got a presumptive positive test while the police chief and several other investigators were actually present. So he was always kind of bothered that this was never brought up at the original trial. So the parties agreed that in the coming weeks, they will submit additional briefing to the court, and on May 29th, they will have another hearing specifically about the DNA motion. Now, in regards to the second motion, the motion for post-conviction discovery, that is regarding specific evidence in the hands of the DA office, which has never in 20 years been made available to Scott. And it really makes you wonder, since they're required to hand that over at the time of trial, what is really going on there? They tried to claim that some of it was already handed over, but many of them are actually just completely new requests. And even the judge didn't quite seem to understand either why these issues couldn't be worked at when the parties met a few months ago.
These two statutes, while I understand that a lot of the issues may be interconnected with the discovery the defense is seeking, I don't see a lot of what they're seeking in the 1054.9 motion appears to me to be in the nature of file reconstruction. Some of it, not so much, but there are things where essentially they're asking for missing bait stamp numbers and other things that are referenced in reports that they already have. I don't understand why that couldn't be worked on in parallel. That's what I'm still waiting to hear. So if the people want to address that, I'd be happy to hear any argument on it.
And the DA's office just kind of references issue preclusion, which means that they already worked on these issues before with Scott and it was already adjudicated. So he was already replied to on that. Well, obviously, if he's asking for it again, plus additional stuff that wasn't originally asked for, it wasn't resolved. But take a look.
Yes, Your Honor. One of the things as it relates to the discovery motion, there was a couple of issues. One is we believe it to be issue preclusion, where in fact there has already been a previous 1054.9 motion that has been brought, has been litigated, and resolved primarily against the defendant back in 2011, 2012. So because of that, we have to go back and we have to call out what has previously been dealt with, and that's requiring us, again, to go back through things that are not necessarily in their materials, but it's in the court record. We also believe that a lot of these items have been raised and litigated as part of the initial appeal and also litigated as part of the first habeas. So because of that, and unfortunately we will be providing to the court or asking the court to take judicial notice of the petition that was there, because a lot of these issues have been raised and have been adjudicated. So because of that, there's a lot of back and forth from the record, and there is going to be a large amount of reading for both sides.
And Paula Mitchell argued that they were very specific about what they are looking for, so it shouldn't be so hard to hand over.
We provided a very, very detailed informal request for discovery on November 14th, 4 months ago. So the district attorney's office has known for 4 months which specific items of discovery we are requesting. We gave them references to Bates pages, we gave them references to where in the police reports the items we're requesting are referred to. We were very, very specific. We spent a lot of time trying to suss out what frankly are very alarming deficiencies in the discovery that was provided to the defense at the time of trial. Those are the items we're requesting. I agree it should not take 180 days for them to locate those items and provide them to us. The defense was entitled to those at the time of trial. Mr. Peterson has been waiting 20 years to find some of these police reports and audio recordings and video recordings that should have been provided. So I don't think that the nature of the requests, it's not a fishing expedition. They're very precise, they're very specific, and we believe that they are probably very easily accessible. So we would ask that they begin providing the discovery that we are entitled to under 1054.9. The prior 1054.9 that Mr. Harris referenced does not include what we are asking for. It related specifically, almost exclusively, to expert materials and other evidence that is not included in our motion. So we are eager to get our investigation underway and completed. The Court of Appeal did give us a very short time period within which to conduct our investigation. The materials we are asking for are reasonable. They're within the scope of 1054.9, and we would like to begin receiving that discovery as soon as possible.
So for that issue, the parties agreed that in the coming weeks, they will submit additional briefing to the court. And on July 15th, they will have another hearing specifically about the motion for post-conviction discovery. Now the last issue, and what I think is potentially the most alarming issue here, was the motion to seal selected last names of individuals in a 54-page letter that the Los Angeles Innocence Project sent to the district attorney on November 14th, 2023. This is where Paula Mitchell flat out came out and said that some witnesses in this case are afraid of police retaliation.
The identity of the witnesses whose names are redacted in the declarations that Mr. Harris is referring to have stated that they are fearful of retaliation by the Modesto Police Department if their names become known, and have asked that their names remain sealed. I would request that we perhaps have a conference in chambers to discuss this issue. It's sensitive to our ongoing investigation. There are a number of other witnesses who we have been investigating who are in a similar situation.
You know something is wrong with the case if witnesses are afraid of the police. What is that about? What is going on here? Now, if that's true, that is very scary, and it should be scary to everybody. And it completely goes against any sort of justice in this country. I was just talking about this case with my son the other day. He's very, very bright. I mean, he's a kid that still rages if he loses Roblox games, but he does like to listen about legal issues when I talk to him. And when I told him the information about witnesses potentially being afraid of the police, he actually looked at me and said, "Mommy, in social studies, we're just learning about something, and it's about how power corrupts and absolute power corrupts absolutely. And he's not wrong, and I couldn't have imagined a better time for him to say that. So that court topic will actually be dealt with first. The hearing date for that motion was set to be April 16th, so just a few weeks away. And from what I understand, the DA's office is even claiming that some of the statements made by the witnesses is hearsay, which is something I assume the judge will have to rule on later down the road. Now, one thing I will say, if anyone actually followed the case 20 years ago, you know that one of the jurors who got dismissed early on clearly stated that he believed the prosecution was not really proving their end of the case beyond a reasonable doubt.
May be innocent. The prosecution hasn't shown us any reason to believe otherwise. The only thing solid they have is the fact that, Laci did wash up where she did and Scott did place himself there, but even that's speculation as to how she got there.
And this juror got literal death threats for making that statement. And to be clear, I am not saying that I believe the police department had anything to do with that part of it. But one thing that is very clear about this case is that there is a lot of hate directed at Scott Peterson, almost alarmingly so. And when you realize that the trial was not actually televised, so that most people who are filled with that much hate for Peterson actually formed their opinion based off media reports and let their own emotions take over, they didn't necessarily actually view trial evidence from both the prosecution and defense, which isn't the way the United States of America could or should work. So at this point, at the end of the hearing, the judge even mentioned that she accidentally opened a message from what she called a spectator about the case.
Last housekeeping matter, the court did, to the court's department email, receive an ex parte communication from apparently some kind of a spectator. I read about one sentence of it, enough to realize it was an ex parte communication, did not read any further, and counsel have been provided, as I understand from the clerk, copies of that email. Did both counsel receive it?
Yes.
Okay, thank you. And the court is not going to be reviewing any incoming email to that inbox in the future to avoid that issue recurring in the future. So people shouldn't bother to email.
Now, anyone out there who thinks it's a good idea to literally start harassing a superior court judge about a case has just about lost their damn mind. I find these people to be abusers of the system and terrorists of potential truth. And for anyone watching who doesn't believe that this DNA should be tested, why is that? I can tell you, if God forbid my child died 20 years ago from a violent crime, and I found out that forensic evidence may exist, you'd bet I want that tested. But even more than that, the country I live in and love says that these things should happen this way. So personally, I say test the hell out of everything and hand over everything they are asking for. If it turns out that someone else out there is who hurt and murdered Laci and Connor, let's get him. And if it turns out to be Scott, he's where he should be. Anyway, with all of that said, those are the 3 dates coming up. April 16th for the motion to seal, May 29th for the DNA motion, and July 15th for the discovery motion. Now, something interesting that people were buzzing about after the hearing was the fact that Scott preferred to appear to these brief hearings over Zoom, meaning he had a chance to leave the prison to appear in court, but he chose not to.
Ms. Mitchell, is Mr. Peterson going to want to be personally present for that or continue to appear electronically?
My understanding is that his preference is to appear electronically, but he can correct me if that is not accurate.
Okay, and let's go ahead and ask to unmute for that. Still muted. All right, Mr. Peterson, we're contemplating an April 16th hearing on the motion to seal the pleadings or parts of the pleadings in this matter. Are you going to want to appear via Zoom or in person for that?
Zoom is fine, thank you, Your Honor.
And all kinds of speculations arose from that, from maybe he's worried about people reading his body language in court, to maybe he's trying to save the court some money, to maybe he has to be shackled and handcuffed and dragged across town for a day when he technically has more freedom on the actual prison grounds. But whatever the reason, it's Scott's prerogative. And to me, really says nothing either way than he just prefers to be there via Zoom. Anyway, those were the key things that came up in the hearing. And I'll keep you updated on any other few nuggets of information that comes up about this case. And as always, don't forget to subscribe and like if you haven't already. And thank you so much for watching. Be careful out there.